Welcome back to the channel, guys. I mean, are you guys exhausted yet with Blake Lively's bullshit? I don't know. I am. I was not planning on going live today either, but I just had to do this. We have more connections between Blake Lively's lawyers and the organizations that are coming out to support her. And we're going to look at that today because, well, wouldn't you know it, another amicus brief hit the docket. I want to know what this judge is thinking at this point. Like, I'm not a lawyer. I'm in branding and marketing. And it just seems like such an abuse of the court's time and the docket. It just seems like all the friends of Blake Lively's lawyers have something to say now. And for anyone that pushed back on me yesterday and were like, but Ashley, an amicus brief is just supporting the law. It has nothing to do with Justin. Well, wait till you see the wording they kick this one off with. Just wait. Because anyone that was on my case yesterday saying it's just the law, it really doesn't have anything to do with Blake or Justin, just wait. Because they come in hot. They make sure that anyone that's kind of on the fence knows exactly what they're accusing of Justin of here. It's wild. Good morning, guys. It's so nice to see everyone. Have you guys had your coffee yet? Where'd my coffee go? I forgot my coffee in the other room. Oh God, this is gonna be a disaster. I forgot my coffee. Guys, I have to get the coffee. You have to hang out. Speak amongst yourself. I'll be right back. I'm sorry, guys. I'm home alone and I can't get through this without coffee. Okay, we're just going to dive in. Let me know what your guys' thoughts are in the chat. Oh, yeah, I need to make coffee. We need coffee. Go get it, Ashley. I love it. You guys are the best. Okay, let's look at who submitted this first. Tundra, we're going to be a good boy, right? And just rest. Why don't you take a nap next to mommy? Good boy. We'll look at who submitted this first, and then I want to show you the ties between Blake Lively's lawyers and the one organization. In fact, I don't have proof of this at this point. I would say it's a good guess or a fair assumption to assume that they have connections to all of these organizations because every single time someone comes out in support of Blake, they have connections to the lawyers. Okay. This amicus brief is Sanctuary for Families is the number one listed there. National Organization for Women, National Organization for Women New York City, Women's Justice Now, New York Cyber Abuse Task Force, Her University Inc., Women's Equal Justice, New York City Alliance Against SA. Gotta be careful, Ashley. Coalition Against Trafficking in Women, National Network to End DV, Esperanza United. I'm not sure what that is, to be honest. I haven't had a chance to check out everyone. As soon as I saw the connections with Sanctuary for Families, I'm like, we're talking about this. New York State Anti-Trafficking Coalition, Her Justice, Urban Resource Institute in support of defendant Blake Lively. It's coordinated. I feel you on that. That's what I'm feeling too. And it's like all at once, all of these organizations. And US Weekly, I think we touched on this yesterday, had already come out with a story about the May 27th one. They're already starting to run with all of these organizations and activists are supporting Blake Lively. So it's appearing coordinated. But let's look first. I want to pull up Sanctuary for Families. See that first. Look at that. Right on their supporters list for Sanctuary for Families, which is the number one listed, the first one listed. This is Blake Lively's law firm, one of her law firms, Manat, Phelps and Phillips, or Phelps and Phillips LLP. If you do just a little bit of digging, there's connections in terms of pro bono work. Now, we're also going to pull up the website for this law firm. And Ezra Hudson, is it Hudson? So many names now. Thought I had her. Yes, Ezra Hudson. She's done a lot of pro bono work as well, but the law firm itself has done a lot of pro bono work. And they put this as a main feature on their website and they celebrate it yearly. So it says here, this is a law firm that represents Blake Lively, who has done and is connected to Sanctuary for Families, the organization that pushed this amicus brief. Dare to imagine a better world. Our clients have great expectations, and so do we. We believe that everyone should have equal access to the justice system. Simply put, pro bono is part of our culture. And I have to give them a shout out for that because I actually do genuinely align with those values of I believe a powerful law firm like this should be available to everyone. And it really sucks when you have people that are vulnerable populations and they don't have access to this type of law firm. So this is amazing. But I also don't see this as, I've done, it's like balancing the scales. I've done enough work in pro bono. So now I can leverage these organizations to help Blake Lively, who at this point has provided no proof, but you know what she's going to say. Well, these organizations in their amicus brief said that, women drop these cases or they're accused of not having proof. And that's why, the people aren't convicted. That's why we need to fight for this. That's going to be her argument. So I do agree that we do need work like this, but I just don't see how you can then argue that, well, it's okay that they're leveraging those connections in this case, because I just feel like it's as shady as shit. And Ezra Hudson, she's on the board. Actually, let's pull up her. So I'll show you guys. We've already talked about this, but for anyone new to the channel, first of all, welcome. Like, subscribe, do all the channel-y things. But just to show that this is a consistent issue. Because I believe it is right on her. I was just looking at it today. Where was it on here? Memberships. So she's done pro bono. So it's still just saying on her website, adoption services for public counsel and Alliance for Children's Rights. It looks like Ezra Hudson likely has a lot of connections in these industries. And here's the thing. A lot of people have said, why are these organizations with children coming forward now? Like, this is speculation. I'm not saying this is 100% it, but it seems reasonable that you have a lawyer on Blake Lively's team that is involved in pro bono work and involved in connections with all of these organizations that are around children's rights. And now all of a sudden we have children's rights organizations that are entering the chat or entering the docket, so to speak. But here it is as well. Board of Directors, California Women's Law Center. That is one of the organizations that spoke out in an amicus brief. She's also a member of American Employment Law Council, member of American Bar Association, which I imagine you'd have to be, member Women's Lawyers Association of Los Angeles. So she's done a lot of work, a lot of pro bono work in the children's field. I don't think it's unreasonable to say she's got connections. And I agree with this as well. You can't just assume that every case like this is brought by an abuser who is being retaliatory. That does happen, but their default position is that it's the only thing that happens. And we spoke about that yesterday where I said, they really in the amicus brief played down the false accusations or that abusers make false accusations that victims make, and then really leaned into, well, no, like even 2 to 8%, that's false inflation of false allegations because women don't, they're told they don't have evidence and they're bullied and defamation lawsuits come out. So they drop it. And it's all these retaliatory things that are causing women to drop the suit. So anyway, let's now look at, because I do have a hard stop today. I know it's like, Ashley's not gonna be able to speak for 3 hours because I talk a lot. Let's look at what this says, because this first opening paragraph really hit it for me. Because it tells you everything you need to know. Let's scroll down. Still scrolling. There we go. The retaliatory defamation lawsuit. Like they don't even play games. The retaliatory defamation lawsuit instigated by the Wayfair parties against Blake Lively is another example of Darvo. They waste no time. There is your headline that they want US Weekly, TMZ, Page 6, all of those publications to run with. And they keep pushing Me Too, which is what we saw in the US Weekly article, which said activists support Blake Lively using a Me Too law and legal battle. These are words that they're hoping are picked up. But right off the bat, they're saying it is a retaliatory defamation lawsuit instigated by Wayfair against Blake Lively and that he's using Darvo. My blood pressure shot up. Yeah, they're assuming he's the offender. Yep. I agree. These organizations need to do their due diligence. Yep. It really shows a likely money or connections talk. So they say Darvo's deny, attack, reverse victim, and offender. In the post-Me Too era, guys, if you watch this channel, we talk so much about SEO and keywords. And what do I always say? You know, when we're looking at articles, so say US Weekly, your first 100 words are prime real estate. This is written more to the press than anything else, because how many people are actually reading, even if the public gets their hands on this, 50 pages? Likely not. They're going to read the first couple pages, and on the first couple pages, they already got what these people want you, which Blake and Ryan and their team wants you to hear. It is a retaliatory defamation lawsuit by Wayfair against Blake Lively using Darvo in a post-Me Too era. Notice I still don't have my Fitbit on. I can't wear my Fitbit when I do this. I can't find my good mug. Today is just like a rush. It's like my mug with my horse's grandma on it. Anyway, you need to laugh sometimes with this. So Darvo in the post-Me Too era is where perpetrators of SA, in particular SH, attempt to silence their victims into submission. Perpetrators use defamation suits to deny their own liability, discredit survivors of SA, SH, and reverse the narrative to cast themselves as the real victims. The smear tactic. There you go, guys. We're getting all of the keywords in the first paragraph. We're not even going to be able to get through the first paragraph without me having an aneurysm. This smear tactic comes at a real cost to victims who muster the enormous courage required to report their abusers in the first instance. If the use of Darvo tactics in defamation lawsuits is allowed to continue unchecked, embroiling victims in costly and drawn-out litigation proceedings that force them to relive their trauma, it will embolden perpetrators and contribute to a culture of silence. This will impact survivors from all socioeconomic backgrounds, including those with the least means to defend themselves, as well as the most high-powered celebrities. So this is respectively submitted in support of Ms. Lively's motion to dismiss Wayfair Party's case on grounds that her statements about the SH she experienced in the workplace on and around the set of filming It Ends With Us and legal filings to the press and to third parties fall within California's recently enacted SH privilege under Section 47.1 of the California Civil Code. Lively mem of law in support of motion to dismiss. I am not a lawyer, guys. I'm in like branding and marketing. So I'm not going to know some of the legal terms, but here we are going through this together. I haven't read it myself yet. The privilege codified in Section 47.1 and similar legislative enactments in New York and elsewhere play a pivotal role in creating an environment where survivors are encouraged to report SA and SH without fear of being sued. Survivors' voices belong in courtrooms, in campus disciplinary hearings, and in public forums. The law should protect survivors' rights to speak their truth, not silence them. With all of the atrocities that go on in this world, you guys have been here for a while, know this. I worked in the mental health field. The amount of atrocities that go on in this world, and this is what you're getting behind. I'm just what you're reading sounds exactly like what Blake Lively is doing. Yes. And I agree with this. It's not actually pro bono work. I agree with you. It's an I scratch your back, you must scratch mine no matter the circumstances. Yep. Oh, for sure. That's a good point too. Thank you for pointing that out. That is a great point. And I completely missed to point that out. So I appreciate that. You guys are the best community ever. Guys, I genuinely, one, my brain's always going to see things for the potential PR angle to anything. It's just how my brain's been trained to work over so many years. The fact that so much was said in the first two paragraphs, and they're using words like Darvo, Me Too, retaliatory defamation. These are all words that would work really well in Google SEO, which again, we've already seen in US Weekly using that in their headline. So I just find this really concerning, to be quite honest. And again, if we talked about this yesterday, I said, I do believe victims, I don't have an answer on how to go about these types of laws because I do believe victims should be protected. And yet the problem is when you have laws like this in place, it shields people that are using it for their own gain. And I think that what all of these organizations should have done instead is maybe bring attention to how maybe, and they didn't have to call out any names, but how it's critical that these laws are not abused, even if they didn't want to get involved with names. Because as soon as this law starts getting abused, and especially publicly, and that's another thing, a lot of these organizations have a lot to lose with this. Because if it is proven that Blake Lively is a liar who lies, and that she used this law as a shield, then what happens? And that's something I've been thinking of the last little bit is that maybe they do have more to gain as well with this. Because if this law gets taken down, because it's proven that people are using it as a shield, I don't know. So they wish to advise the court of the potential chilling effect and unfavorable application of Section 47.1 in this highly publicized case will have on victims seeking to protect themselves, report abusers, and raise awareness with the public. And active contributions and experts in the scholarship surrounding the dynamics of SASH, Amici are uniquely qualified to assist the court in understanding the interests of victims with respect to the issues of common public concern. I didn't take my headache meds. I should have taken my headache meds. Like, how's the court going to... We know better than you, Judge. We know better than you. Listen to us. It's okay. We'll tell you what to do. Argument: perpetrators increasingly employ Darvo tactics in the workplace and through meritless defamation lawsuits to silence their victims. And who uses the press again? Blake, I keep forgetting. Who uses the press for PR, girl? Remind me. Last time I asked you a question, though, within a couple hours, my video got taken down by YouTube. So Darvo is a term initially coined by Jennifer J. Frey to describe the Can you always tell when I'm like struggling internally? Did I pronounce that right? Probably not. To describe the perpetrator tactic to deny committing any wrongdoing, attack their victims' credibility, and cast their victims as the real aggressor and themselves as the real victims when held accountable or confronted with their abusive behavior. In application, Darvo is a tactic used to urge observers to believe that the only wrongdoing is a false accusation, a terrible injustice brought on by someone pretending to be a victim. The premise is simple. When facing allegations, many accused individuals are more likely to victim blame to shift the narrative. As some have suggested, Darvo is a form of gaslighting in the sense that the person using the strategy gaslighting. What? Come on. Come on. You guys cannot say this with a straight face. Are you kidding me? Guys. So Justin is gaslighting us and gaslighting Blake, apparently, because they called it out. They said from the first sentence, Justin, Wayfair are using these defamation lawsuits for Darvo. Those are their words. They started out. So anyone on my case about it, there you go. They made it very clear what they think. Just for anyone in the back that was like wishy-washy on it. But Darvo is a form of gaslighting in the sense that the person using the strategy rewrites the narrative and rewrites the version of events. In this sense, perpetrators of interpersonal violence thrive when victims are silenced. I don't know, because the only one that thrived when a victim was silenced was Blake, because she took over the movie, took over the marketing, had maximum effort come in to do all the marketing, and Justin was in the hospital and in the basement. Did you all not check that? Because as Blake was right, I know you guys did. Just speaking directly to all these nuts. Because as Blake was taking over the marketing, there are text messages where he says, I'm not going to die on this hill, whatever, basically, do whatever you want. Taking over the movie, doing her edits, marketing, she said, we're like the mafia, Ryan and I. We'll take care of it. He was in the hospital sick. And then she throws a temper tantrum like a petulant child when apparently she has to turn over Discovery, which, oh my God, who would have known? Discovery of her mental health when she was trying to leverage Justin's ADHD against him in the public and doxed Jed Wallace's health problems. Don't tell me, damn it, I should plug in my computer. Don't tell me about, I was not expecting to go live today, if you could tell, about gaslighting Blake and co. Oh God, sorry guys, making a lot of noise. If you can tell, I was not planning on this. But I was like, I need to be with my people right now. I need to be with my people to go through this, because at least if I have a health crisis over this, there's going to be people online that can like call the authorities or something. In an attempt to understand how Darvo tactics are applied situationally, studies have focused on observing how individuals react when they're confronted with allegations of wrongdoing. Yeah, Blake, how did you react when you were confronted with allegations of wrongdoing? How did you react? You went scorched earth. In one study, college students and general community members were provided a short-form questionnaire with a series of statements representing Darvo methods, including denial, attacks, and reversal of victim and offender. Participants were asked to consider a personal example where someone confronted them with a serious allegation of any kind. Each participant then measured their own use of Darvo during that confrontation, including denial statements like, that never happened, and whatever you're saying happened isn't my fault. Attack statements like, you're acting crazy, and no one would believe you if you said anything about it. Reverse victim and offender statements like, I'm the real victim here, and you should be apologizing to me. I do think Blake owes everyone an apology. So it sounds like she's the one using Darvo. After considering these items, participants rated their own responses on a scale of 1 to 5, from not at all like this to almost exactly like this. Nearly 1/3 of undergraduates and nearly half of the general community population reported using all 3 Darvo elements during a confrontation. And the undergraduate population, the study found that individuals who reported using higher levels of denial during confrontations were also more likely to employ personal attacks and attempts to portray themselves as a real victim. Additionally, individuals who issue denials, personal attacks, and reversals of victim and offender roles as a means of responding to confrontation are more likely to hold victim-blaming beliefs and SH others. As these studies suggest, when confronted with allegations, perpetrators are inclined to use Darvo tactics to counteract and shift blame. Okay, I need to record what study this is. I'll deal with that after. So what I'm understanding, let me know if you are understanding this as well, is this is not on like perpetrators or victims. So let me know. I want to hear if you guys are taking it the same way in the chat. Do I want to know how credible this study is? Yeah, good question as well. Because whenever you're looking at studies, guys, and you can get really any answer you want at the end of the day, depending on how you frame something. But the way I'm understanding this study, and again, this is first glance through with you guys. I read the first paragraph, almost had a stroke, and then I was like, I need to go live with you guys. The way I am understanding this, and I'm going to sit with it later tonight after client calls and everything, is that this was simply a study on college students and general community members. So not on victims, not on perpetrators. And they asked them random ass questions. Did they take into consideration trauma responses? Did they take into consideration attachment styles? Not that it's like an excuse, but the average person tends to get a little bit defensive. And someone might say, like, that never happened. But then they sit with it and they're like, oh shit, I'm sorry, I didn't realize that happened. Or they work, you know what I mean? Like, I'm just not understanding, other than saying, and how did they make this conclusion? Individuals who issue denials, personal attacks, and reverse the victim and offender roles as a means of responding to confrontation are more likely to hold victim-blaming beliefs and SH others. How did they make that conclusion? Did they follow these people to then say that, oh, those that were consistently saying that person's acting crazy, it's never my fault, they should apologize to me? Did you follow them over the course of 5, 10, 15, 20 years, 50 years? To then say, oh, okay, yeah, now, those people that had answered in that way over the course of 10 years were more likely to be charged with SH or SA. Because I can't imagine this study did that. I might be wrong. I'm going to look into it. But it just kind of seems like a self-reported kind of thing without taking any consideration into anything else. And I work with a lot of clients, even in like personal development and with human design. You guys that have been here know I love human design. I work with a lot of clients in the personal development field in terms of human design and more deconditioning or working on your shadows. There's a lot of people that might initially think, because of trauma in their past or whatever, well, this situation happened, that person was acting crazy, but then they come to someone like me to understand those patterns and to work through it. It doesn't mean someone's just a horrible write-off person. We all have our fucking faults. None of us are perfect. So I just want to know how this study, I'm going to look into it. I'll keep you guys updated, but I do not believe this study followed these individuals, which is what you would typically do to then make a connection like that. To say these individuals that answered this way were more likely to SH people. You would follow them, maybe track court documents and see that charges came up against them. And I doubt that happened. Blake Lively or flying monkeys will ruin things for women for generations to come. Yeah. Alexa, play This Is Why We Can't Have Nice Things. Have you noticed I've been playing that so much in my Instagram stories? That song comes to mind all the time. They want to make the court look like it's a legit law. I agree with you. And so I don't see how this study has any relevance to this case. Any at all, other than, as you're saying, and I agree, that it just is trying to like bolster it a bit. As these studies suggest, when confronted with allegations, perpetrators are more likely to use. No, it does not suggest that based on what you put in here. I will look into it, but that's not what it suggests, because you're not saying oh God, whatever. I need to move on. The use of Darvo tactics in the workplace. Darvo tactics are frequently employed in workplace settings as a means to undermine a target's credibility and standing. Workplace SH, which includes sexist or hostility, coercion. I'm sorry, guys. I'm trying to avoid saying things that get my video strikes against my channel. Unwanted attention is significantly underreported. Data suggests ultimately, or approximately 5 million workers are victimized by workplace SH annually, and yet only 1 in 11,000 file a formal charge with the U.S. Equal Opportunity Commission. While survivors often do confide in friends or family, where? Blake? Because I feel like if you had that text message that was saying, hey, Taylor, Justin is such a creep. This is what happened today. I feel like you would have put it in one of your reports. Oh, damn it. What did I do? While survivors often do confide in friends or family, SA disclosure in the workplace is understudied because formal reporting rates in the workplace are so low, about 25%, even though prevalence remains high. 130 cases filed to the EEOC in 2015 were SH claims. Despite incentives for both employers and employees to identify workplace harassment, EEOC reports on the study of harassment do not dispute that workplace harassment often goes unreported, and that up to 90% of individuals who experienced harassment never take formal action against the harasser, such as filing a charge or a complaint. While EEOC charge data reflects a slight uptick in charges in the 2 years following the Me Too movement, they just love adding that word in, that first emerged in October 2017. From fiscal years 2018 through 2011, SH charge receipts have repeatedly declined. Organizations such as National Blank Violence Resource Center have compiled data further confirming that workplace SH is common but is rarely reported. For example, 38% of all women and 14% of men have reported experiencing SH at work. And 1 in 7 women have sought a new job assignment, changed jobs, or quit a job because of SH and assault. In some industries, more than 9 in 10 women shared that they have been SH'd. This included 69% of those surveyed being touched, and just under 40 were shown pictures without consent. So I'm guessing this is speaking to the picture Jamie Heath showed Blake of the home birth. And the 69 of being touched, I wonder if they're talking to that, like the dance scene. 60% of women experience unwanted attention, coercion, crude conduct, or comments in the workplace. Despite the prevalence of violence in the workplace, over 80% of people who experienced SH never file a formal legal charge, and approximately 70% never address their complaints internally. Blake had like a 17-point checklist and then took over the movie. I don't know. I'm trying to stay on path today because I do have a client. So I'm gonna have to like end no matter where we are. One qualitative study identified victims who described, but let me know what you guys are thinking in the comments, because I love seeing what you guys are thinking too, who described negative reactions from their employers after reporting SA in the workplace, including not being believed, not offering support in the workplace, or even actively harming the survivor through lost wages or harassment. And we talked about this yesterday. Blakey Poo is represented by WME, and Ari Emanuel pulled all this shit on Terry Crews. And I have under the media manipulation playlist. If you're new to the channel, hey, welcome. Make sure to like and subscribe. But check out the media manipulation. I think it's the media manipulation playlist where I talk about Terry Crews. So, you know, Blake, if she had such a problem, I don't know if I'd want to be represented. And maybe she didn't know previously. I don't know. But I mean, this is exactly what Ari Emanuel did to Terry Crews. So study participants described the harmful impacts on the recovery, ranging from poor responses to reporting of workplace SH, including lack of appropriate responses, to the creation of a toxic work environment and termination of employment. Yeah, all of this happened to Terry Crews at WME. If you ask me, the problem is Hollywood. Like, it is a culture of take what you want, no matter who's in your path. And now a law that is meant to support real victims is being dragged through the mud because of Hollywood and their inability to just take no for an answer. There have been accounts of Darvo's application in the workplace to not only silence victims, but also Blake just kept taking over the movie. She was not silenced. Are you kidding? You cannot with a straight face put in an amicus brief that Blake was silenced. That is the most asinine statement I've ever heard. But also undermine victims' mental health and well-being. Well, Blakey's removed the mental health. Take that up with her. Will maintain the status quo within organizations. These effects can create self-doubt in victims, raise questions about whether a victim is too sensitive or misunderstanding workplace norms, and lead to a situation where victims stopped raising concerns altogether, since the outcome often leads to begging more questions like, why speak up when the result would be feeling worse than before? Victims emphasize that Darvo's effectiveness relies partly on making the target feel alone in their experience. I do not. Come on. She's threatening the guy with her dragons. Blake did not. Come on. She did not feel alone. She was threatening him with her dragons, and then it turns out Ryan was on the set all the time. Didn't she have like her mom in the edit room or whatever they call it? Victims emphasize that Darvo's effectiveness relies partly on making the target feel alone in their experience, creating psychological stress, anxiety symptoms, and dreaded interactions with supervisors. I would not even be surprised if their new PR angle is, look, we didn't want to drop 10 and 11. We had no choice but to drop 10 and 11 because of the immense stress and psychological damage that was done. And she just can't be put through that again. And look at all these organizations that came out and said that it's true. Look at all these organizations that backed Blake up. That's why we had to drop 10 and 11, because they're bullies and they're abusers and they're forcing us through this invasive discovery process. See the chilling effects of Darvo tactics and defamation lawsuits. Participate in re-traumatizing, expensive, time-consuming, and hostile legal process is chilling and upsetting. As courts like the New York Appellate Division First Department have recognized, SA remains vastly underreported, primarily due to victims' fears of retaliation. It does not escape us that defamation suits like the instant one may constitute a form of retaliation against those with the courage to speak out. In a 2021 report to the General Assembly, UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, Irene Khan, warned of a perverse twist that women who publicly denounce alleged perpetrators of SV online are increasingly subject to defamation suits or charged with criminal libel or the false reporting of crimes. Why is it only women? Can men not be victims? Genuine question. The idea that victims are deterred from speaking out about their abuse or retaliatory lawsuits is supported by scholarships and experiential evidence. These same concerns have been echoed in contexts where victims seek protective orders and application of Title V2, where the threat of defamation suits can discourage complaints. For perpetrators, offensive lawsuits are an opportunity to enforce Darvo through civil litigation. What a nut. Strategic lawsuit against public participation, or SLAPP suit, as coined by Professor George Ping and Penelope Cannon, were first used to quash controversial speech in the 1970s and 80s. As scholars note, SLAPP suits are designed to chill or punish the speech of individuals or organizations who speak out on issues of public interest or concern. And when used to threaten litigation or to overtly and covertly attack the credibility of victims, a defamation lawsuit in this context is therefore enacted Darvo. These lawsuits have provided an avenue for targeted legal attacks against survivors of SA or domestic violence, especially with the Me Too movement that catalyzed an upsurge in SLAPP suits brought by the accused with the sole intent to intimidate and silence their accusers, leaving survivors of those without financial resources to defend themselves. Statistical evidence confirms the increasing usage of Darvo tactics, including the weaponization of the law against victims. For example, a 2016 survey of undergraduates, here we go again with the undergrads, analyzed responses that each participant received when asked an open-ended prompt to share a time when you confronted someone who wronged you in some way. After being asked to recall a specific time they confronted someone else over their wrongdoing, participants were asked how much phrases in a questionnaire resembled 3 Darvo elements: denial, victim blaming, and assuming a victimized role. On a 5-point scale from not at all like this to almost exactly like this, nearly 72% of participants indicated they heard at least one phrase each from all of the 3 components of Darvo, which show that Darvo was indeed commonly experienced by individuals who confronted another person over a wide variety of wrongdoings, ranging from milder social indiscretions between acquaintances to more severe interpersonal abuses. And again, my problem with this is, one, it's no relevance, but 2, unfortunately, people as a whole, we struggle sometimes, or we get defensive, or we have insecure attachment styles, or people fawn, or whatever. We as humans have a lot of shit to work through. Just because an individual might respond like, be in denial that they hurt someone doesn't mean that they're an SA or an SHer or that they have an increasing likelihood to commit crimes later in life. And if there is a connection, I would have preferred that study being put in rather than this bullshit, because this is not saying that those statements alone, again, you're not following these individuals or following the person that's saying certain statements and then proving that there's like a 72% chance they become SHers or SAers later in life. We all have shadow work to do. All humans kind of suck at certain points of our life and in certain situations. It doesn't mean that someone's going to become an abuser. This is wild. In 2017, one attorney who worked with campus SA victims, why do we keep going to campus? Why don't we just get proof from Blake? That's what I'm thinking. This study is clearly an undergrad research project. The data has been incorrectly interpreted. I agree. 100%. This is wild. Yeah, just back up your claims. And I think what she's going to try and pull is like, look, they're supporting me that, everyone blames the victims, that they don't have enough evidence. It's likely going to be exactly what her team's going to go with. But this, I agree with what you guys are saying about the campus studies. That's likely an undergrad study someone did, because it's so misinterpreted and it's being misused in this. In 2017, one attorney who worked with campus SA victims shared that previously only a small fraction, 5% of her cases included defamation lawsuit, but more recently that number has jumped to about 50. Again, is it increasing because people are being retaliatory, or is it increasing because people are sick of, maybe someone's been falsely accused and they're defending themselves? Being retaliatory and defending yourself, in my mind, are two very different things. A 2020 review, and again, I don't have an answer. I'm not pretending I know exactly what the law should do, because I do agree there needs to be protection for victims. And laws also need to, in my opinion, take into consideration that false accusations are made. And if everyone that defends themselves against false accusations is deemed Darvo and retaliatory, to me, that's a problem. And to me, the law needs to be looked at. And I feel, again, my opinion, these organizations could have better used their time to look at how do we make this law better, so it can't be manipulated. The lawyer's name isn't Ezra by any chance. I don't know who. Ezra Hudson is Blake Lively's lawyer. Yes. One of them. And she's on the board of the other organization that I keep forgetting the name of that one, but the California Women's Law Center, for those that are just hopping on. So it's already been proven that Blake Lively's lawyers have connection to these. For anyone just hopping on, Manat, Phelps and Phillips LLP, which is Blake Lively's law firm, has done pro bono work for Sanctuary for Families, which has submitted, the main one that submitted this amicus brief. So there are a lot of connections between Blake and these organizations. For survivors of violence, slaps can be especially chilling. Well, there has been a historic understanding that victims have chosen not to report their assault for many reasons, including financial consequences, guilt, fear of discrepancies, and their stores and public, I'm guessing that's supposed to say in their stories, and public shame. Now, liability resulting from highly visible defamation suits may be another. Again, I do agree it can be a problem, but I also believe there needs to be protection in the event that false allegations have been made. Individuals have shared that verdicts, in particular in high-profile celebrity cases, cause apprehension about pursuing relief. Who did that one? Who? Reminds me of It Ends With Us. Who? If you've watched It Ends With Us, you probably know what scene I'm talking about. But anyway, did Amber say that? This is the purpose of Darvo instigated lawsuits, because Darvo was a huge thing that she ran with. Instigated lawsuits to dissuade victims from speaking out. Ms. Lively's case, however, is critical for victims to see that protectionist statutes like California, they're putting her as the poster child. California section 47.1 will shield them. So they may report abuse and seek protection without fear of retaliatory litigation. They are using Blake as the poster child for this law. Oh, sorry, I just hit my mic. Sorry, guys. Sorry if you got like a big bump in the ears. State legislators have responded to the rise of meritless. I am just shook. I'm going to have to sage and do a quick meditation before I get on client calls. So the rise of meritless Darvo defamation lawsuits by enacting laws affording greater protection to victims of SV. Guys, I keep thinking it can't get worse and it does. And it's really disheartening for me as someone that's been in this field. I've been in this field. I left this field from being burned out because there wasn't enough protection for victims. And just to give you a little bit of backstory, one of the group homes that I was a supervisor at was with like high risk youth and youth that were in and out of jails. It was a particular interest of mine to help from these youth from reoffending. And so the age was 18. At 18, it's like, peace out, you have nowhere to go. But then the problem, and it might be better now, I'm not as integrated into that world anymore since I left the field, but then they had nowhere to go till 21. So you'd help these girls and try to get them set up for a good life and to support themselves. And then 18, you're like, nothing I can do. Bye. And at the one place I was a supervisor at, we did try to help them past the age of 18, but then you had struggles because you had adults that necessarily didn't have to follow the rules in the same place as youth that did have to. It was just a mess. So I left this field because of the issues that are in this field. The mental health field and law around mental health and SV and SA is horrific. There does need to be certain reforms, but I just don't think, in my view, it just means like, well, sorry, if there are, what the feeling I get from reading the Amicus Briefs from yesterday and today is it sucks, man. If there's like a false allegation, like take one for the team, buddy. Take one for the team because, you know, all the good it's doing, you just got to take one for the team. And I'm also not okay with that. It's not okay. So in response to ill-motivated SLAPP suits, state legislators have proactively sought to enact or amend laws to protect individuals engaged in protected speech, commonly known as anti-SLAPP statutes. As of January 2025, 34 states and the District of Columbia have enacted, we did this yesterday. They were talking about how great it is that other states are doing shit like this too. These enactments permit early dismissal of meritless SLAPP suits, save costs, and protect free speech. Such anti-SLAPP suits like Section 425.16 of the California Code of Civil Procedure were enacted to allow dismissal of meritless First Amendment cases aimed at chilling expression through costly, time-consuming litigation. Notwithstanding the underlying purpose of anti-SLAPP statutes to prevent meritless nuisance suits, so now he's a nuisance, many of these laws originally did not include express language aimed at protecting victims of SA, abuse, or discrimination, or built-in protections for victims forced to defend against such lawsuits to reduce the financial burden of the litigation. As a result of advocacy work by organizations to raise awareness of these issues, policymakers in California, New York, and Illinois have introduced and enacted bills to add explicit protections for victims of SV or harassment from being targeted through retaliatory defamation suits. Legislator in those states, including New Hampshire, Delaware, can you tell I'm not American? Delaware, Oregon, and New Jersey have introduced similar bills to statutorily protect victims against such lawsuits. In this part, Amici aim to equip the court with additional context behind these statutory amendments and demonstrate that they were intended to afford greater protection of speech to victims in Miss Lively's current situation. I hope anyone that came at me over they're not defending Blake Lively with these is seeing this. I mean, we started out with hardcore them throwing Wayfair under the bus. I just can't. Blake really wants those triple damages. Yeah. Is there a way to like put it more than 400 million? Because to me, it just feels, and again, I'm not a lawyer. What do I know? But it just feels like me. And again, having that eye of like PR and how her team can potentially twist this, which is what we're already seeing with the US Weekly article, is even if her team doesn't necessarily, like they can hint, right? They're like, oh, it wasn't us that told them to run with this. You've had so many of these activist organizations coming out with using the same words, the Me Too, the Darvo, all of this retaliation. You know what's going to happen with the press. You know you're setting him up. You know. She knows. They all know. They're manipulating the courts. They're manipulating the public. And I think this is just another little loophole hole that they're doing to be like, we're not litigating this in the press. What are you talking about? What are you talking about? This is not even us. We're not filing these. What are you talking? We're not like Brian Freeman over here putting it all out there for the public about how we're extorting Taylor Swift, allegedly. No, all of these organizations are coming out to support us. It's not us. It's not us. There's no emoji. Otherwise, I would have lit up the chat. There is no emoji at this point to encompass this case. I don't think Blake's team is focusing on her SH claims. I think they feel like they're going down. They might at least win the defamation case. That's a good point. Good point. All right. What time is it? I really struggle to speak in under an hour. Okay. This is why I do so much pre-recorded content so that my whole day isn't streaming as much as I love hanging out with you guys. California's anti-SLAPP law amendments. In 2019, California amended its civil code to expressly provide protections for individuals who make communications about SV without malice. So I think we've proven Blake has done this with malice. Have we seen what I like to call Shamzan? Shamzan had 10 Jane Does. There is no way Blake, Leslie, and all the flying monkeys didn't know who those Jane Does were. I don't believe it for a minute. The only reason Blake used Shamzan lawsuit was to be able to file all this shit in secret so that Justin didn't have a heads up on what's going on. So Jennifer Abel and everyone else didn't have a heads up on what was going on. Tell me again how that's without malice. Sanctuary for families. I would love to hear. I'd love to hear. Because again, I was on Blake's side in the beginning. I was telling the chat, I was like, guys, I don't believe you. She just has crunchy energy. She's just got like this tough energy. I don't believe you. And you guys are like, girl, no. And then I said, I'll admit if I was wrong. And then like a month later, I'm like, guys, hang my head in shame. I was like, I was wrong. Specifically, the law amended provides that a communication that is made by an individual without malice regarding an incident. All right, so it's privileged. Communication applies to a variety of forms of SV. We're just going to skim through some of this because we still got a long way to go and like 15 minutes to do it. The legislative history of Section 47.1 of the California Civil Code provides additional context and understanding the harm state legislators like California intended to address after the Me Too movement began. There we go. I wonder how many times Me Too is in this. I'm going to check after. I'm going to make a note for myself because I will forget. ADHD is real. All right. After the Me Too movement began in late 2017, lobbyist Pamela Lopez publicly accused former California Assembly member I'm not even going to try. of essaying her at an event in LA. Ms. Lopez initiated a formal complaint process with the California Rules Assembly Committee and gave a press conference that detailed the incident, identified this individual, and generated significant publicity. Thereafter, in August 2018, Matt sued Ms. Lopez for both her complaint to the Assembly and the press conference for defamation and intentional infliction of emotional distress. After filing an anti-SLAPP motion arguing that her complaint and press conference were protected under 47 of the California Civil Code, the trial court, slow down, Ashley. The trial court ruled her complaint was privileged, but her statement to the press was not subjecting her to Matt's claims. Despite the appeals court ultimately finding in 2021 that both Ms. Lopez's complaint and press conference statements were privileged, her experience highlighted the danger posed by retaliatory defamation and related tort claims for those who suffer SA and harassment. So they're arguing that you can also hold a press conference. So they're saying like, yeah, so what? How about them apples? She went to the New York Times. Too bad, protected. Try again. Guys, I just can't. And I love, again, they're not using like Terry Crews as an example. How about that Elise Dorsey? That activist that came out with an amicus brief that turned out she was having an 11-year affair with someone, I think it was a professor. And then when it was ended, the affair, she turned crazy, allegedly, based on court documents and based off of the fact that he won his suit against her for false allegations. Yeah, that is someone else that Blake Lively has supporting her. Blake Lively has all the gems supporting her. So basically what this paragraph is saying is Blakey's protected for having gone in the New York Times because she can say whatever she wants. She can hold a press conference in Town Square and call him a predator all she wants. And guess what? Y'all can't do shit about it because it's protected. Again, I think this should concern people. I think this should concern people because there are false accusations that are made. And what's the recourse for people? And here's the thing. If you're saying that people can hold a press conference and that's all protected under this law, look what happened to Justin. He lost WME representation. He lost awards. He lost contracts in movies, et cetera, et cetera. So what's their recourse, that person's recourse in the meantime? For people that are, yeah, this law says there is no recourse. Exactly. There's no recourse. You just got to take it. People can say whatever they want. And as long as it's without malice. But then my question that we talked about yesterday in the live stream is I said, well, how do you then prove it's with or without malice? Because it's basically saying, well, we just assume it's without malice. Like, come on, no one's going to, this isn't malice. Get your head on straight. But it's assuming everyone's good and that no one is self-interested and willing to take other people down and leverage this law as a shield. And while I like to believe in the good of humans, having been in these fields for so long, I know that not everyone is good. I think they have the potential to change, but so there you go. She should be able to say whatever she wants, and he just has to take it. In February 2023, the California legislature first introduced 47.1 comments to the Assembly for floor analysis, acknowledged that enacting Section 47.1, would codify then existing California law that already protected communication made without malice. Again, how do you prove? And then the press conference is already out there. And would also potentially help curb any unnecessary and ultimately unsuccessful litigation against individuals who choose to come forward with their stories of SA and SH. The amended was intended to dissuade litigation against those who have made the difficult decision to come. Blake's a hero, guys, to come forward with their experiences and dissuade a perpetrator who would otherwise opt to silence survivors by targeting them with litigation due to the significant potential damages and penalties provided by this bill. We're just going to zoom, as Emily D. Baker would say, through some of that so we can at least get through the document. The New York anti-SLAPP law amendments in 2019. Can you tell I'm watching a lot of Emily right now with the Karen Reed trial? In 2019, New York Senate Bill S52A was introduced and amended Section 70A and 76A of the New York Civil Rights Law to expand New York's anti-SLAPP statute by protecting defendant victims in legal actions involving public petition and participation. New York Civil Rights Law 70A and 76A, the intent of New York's amendments was clear. The express intent when it amended the anti-SLAPP law in 2020, proclaiming repeatedly in legislative memoranda, press releases, and other public statements that the prior law had allowed survivors to be dragged through the courts on retaliatory claims solely intended to silence them, and that the new law would protect survivors. I don't think Justin's ever tried to silence her. That's never been my impression. He only said really nice things about her. And then he was silenced. And he hasn't been able to say anything since, because every time he has said anything, Blake Lively comes out with abuse our Darvo, abuse our playbook. So again, just like this is also to protect free speech, particularly where such rights are exercised in public forum with respect to issues of public concern. So they're just like hammering that she was within her protected rights to go to the New York Times, that Blake's allowed to speak out. She's within her rights to speak out, but Justin's not. That's all they're saying. That's all they're hammering down. Additionally, a sponsor memoranda make it clear that New York courts seldom impose remedies to defendants of SLAPP suits, evidencing a failure to use their discretionary power to award costs and attorney's fees to a defendant found to have been victimized by actions intended only to chill free speech. Legislative efforts impact victims. Both California and New York recent statutory amendments reflect legislative efforts to statutorily protect victims from retaliatory defamation lawsuits and the importance of broad language in anti-SLAPP suits. These laws provide clear standards and financial relief by way of recovering attorney's fees. So she's going to try and recover attorney's fees and costs for defending against harassing litigation. He's harassing her apparently, which may cause barriers for victims when they're defending against the burdensome and costly actions bought by their perpetrators. The impact of these statutes can be very real. Estimates suggest that 1 in 3 women and 1 in 10 men experience unwanted contact, and yet only 1 in 20 experiences of SV is actually reported. In a world with these statistics, anti-SLAPP statutes that do not provide additional protections to protect victims from meritless defamation lawsuits will continue to chill reporting. One scholar reported the story of a victim who spoke out about her abuse by a White House staff member and was sued by her abuser for $4 million. The victim was sued in Massachusetts, a state without any anti-SLAPP statute. Yeah, okay. We're just gonna. Oh, interesting. Interesting. New York's amended anti-SLAPP statute also protects journalists who exercise their First Amendment rights when reporting on misconduct. Well, there you go. But here's the thing. Watch yesterday's live stream, because on yesterday's live stream, was it Leslie Sloan is going for, I can't even keep all these people's names, Sarah Nathan. So I think it's Leslie Jones. You'll have to watch yesterday. Leslie Jones is going for Sarah Nathan about 2 articles she put out, and she's trying to prove, she subpoenaed Sarah Nathan, trying to prove that Sarah Nathan, Melissa Nathan's sister, is in on the smear campaign against Blake Lively by Wayfair and Justin Baldoni. So you're going to have to watch. I time-stamped yesterday's. So just zoom down and watch that. It's closer to the end. So New York's amended anti-SLAPP, what they're arguing is like protect Blake. But again, it's not for anyone else. So the journalists that were supporting Blake are safe, but no one else. Journalists who exercise the First Amendment rights when reporting on misconduct, like Michael Balter, who was sued by Danielle Curran, an archaeologist at the University of California, Santa Barbara, after he did exactly that. In 2020, Mr. Balter had reported on Curran's abuse and retaliation of her students through several posts online and a letter to the Honorable Vincent L. Bricetti, just 2 months after New York modified its anti-SLAPP law as described supra. Mr. Balter's counsel advised the court that he intended to apply the statute to Mr. Balter's case. The amended language in New York, while designed to protect women, also protects journalists who seek to share those stories because they are matters of public interest, which was added to the law. I wonder if this is why the New York Times, because didn't they, like, isn't it paused, kind of, the New York Times one, Discovery and everything? And now we have these organizations coming out and being like, the journalists are protected too, BTW. Makes you think. Again, in response to the previous anti-SLAPP statute's language, the amendments aim to provide more protection and in turn promote more speech. Oh, there we go. Keep reading, Ashley. Just keep reading. What time is it? Oh, okay, guys. Miss Lively's statement about her workplace experience of SH and the New York Times reporting of the same are precisely the kind of statements that the California and New York statutes protect as privilege. Were you guys like, Ashley, just keep reading? It's literally right there. Like, go down a line, girl. Go down a line. Now it makes me wonder if this is why New York Times was trying to delay Discovery. Yep, this sentence is the crux of it. I agree with this. Why is she fighting so hard to be dismissed if she has truth on her side? Exactly. I agree. This is everything. But the irony of it, my friends, again, make sure watch yesterday's live stream, is Leslie Sloan and all of these individuals are going for Sarah Nathan with a subpoena to try and prove that Sarah Nathan was a part of a smear campaign. So what they're arguing is Blake can say whatever she wants, but no one else can. So Miss Lively's statement about her workplace experience of SH and the New York Times reporting of the same are the kind of statements the California and New York statutes protect as privileged. Indeed, California's amendments were motivated by statements made to the press about a prominent figure, which is symmetrical to Miss Lively's statements that were communications about her experience of workplace harassment that were then published in the New York Times. Holy shit. Amici are highly familiar with how reluctant victims are to come forward to confront their accusers, even in the wake of Me Too. The threat or reality of defamation suits further serve to silence victims. When aware of the realities, legislative decisions to prioritize and protect certain rights must be respected. Here, that is the right to speak about one's own experience and seek legal action without fear of those statements being subject to liability. I have chills. You want to talk about a chilling effect, Blake and lawyers? I have chills. I know. Ashley said 23. I know. I literally have a call at 10:30. So we're probably not going to get through all of it. I'm sorry, guys. I talk too much. The statutory protections Miss Lively has invoked under California law, which are similarly enshrined in New York law, protect her from precisely the kind of meritless claim the Wayfair parties have asserted in this case. The Wayfair parties' attempt to undermine those statutory protections are meritless and would further serve to chill victims from reporting their harassment, knowing they could be subject to civil liability. A rule dismissing the Wayfair parties' lawsuit would further advance the legislative intent behind recent enactments. Since the rise of Me Too, which originated in the entertainment industry, SV has generated widespread publicity. Disputes involving celebrities and the resolution of their cases carry enormous cultural impact. They're using her as the poster child. As some have observed, the impact of Me Too on Hollywood has been profound and far-reaching, leading to shifts in hiring practices. Yeah, ain't no one going to hire Blake after this shit. But Blake only has herself to blame for this. The movement made these issues impossible to ignore by empowering millions of survivors to share their stories, leading to a broader understanding that SV is not merely a series of isolated incidents, but rather a widespread systemic problem. The same time, it was met with backlash, including through defamation lawsuits where social media in particular has been used to attack the credibility of victims. So you think that's a statement to everyone that's covering this case? Oh, damn it. Where did it go? In minute-to-minute updates of ongoing court proceedings, hi guys, hi. Especially in high-profile cases, the public can observe firsthand in real time how victims are second-guessed, commented on, and ridiculed, which can have chilling effects on those contemplating reporting their own experienced harm. Wow. So Blake can say whatever she wants, but not only can Justin not say anything, but social media can't say anything, YouTubers, content creators, no one can say anything but Blake. The court's ruling will have a broader impact beyond the entertainment industry and beyond the litigants in this action. And I will say on this channel, I work really hard to have a community where we're not just like needlessly ripping her to shreds as well. I just can't believe this. While the litigants in this action are well-resourced, most victims are inhibited by social economic limitations. Maybe defend them then. Maybe spend your energy on that shit. Because the only thing that's going to happen with this case is people are going to start second-guessing this law because of Blake. Dismissing meritless defamation lawsuits at an early stage is also important to encourage reporting of SB or harassment, since victims seldom fabricate stories. Guys, did you see that yesterday we saw it's 2 to 8% of false allegations? Now it's less than 1%. Now it's less than 1%. Yesterday it was 2 to 8% are false allegations. And in this report, so what is it? So it's like you just have to believe her. Like that is literally what they're saying. You just have to believe her. If people make claims of SA or SH, you have to believe them, and they can say whatever they want, and there is no repercussions or action that people can take. So now it's less than 1% are false allegations. Oh, fuck. Sorry, guys. I did not mean to click on that. We're not even gonna have time to find it again now. Where did it go? That's how worked up I am. So yesterday was 2 to 8%. Now it's 1%. Either way, I have to bounce. I'm just shocked. So basically the argument overall is that you just have to believe Blake. Not able to find the page. I don't know what page I was on. All right. Let's see if there's anything else. Oh, there it is. Other reports have shown that due to terminology differences or methods to evaluate data, the prevalence of false reporting is 2 to 10%. But it's, it has to do with the terminology. Yesterday, it has to do with them, the trauma of reliving it or being told they don't have enough evidence. That's why it's 8 to 10% or whatever they said. Especially true when victims already underreport because, for example, 20% of victims feared retaliation. All right, guys, that's basically it. We hit the end. They list all the organizations. We did get through everything, though. I do have to bounce. I have 2 minutes to grab some water, get a refill of coffee, and get on my client call. What are you guys feeling? Time to go. Yes, I gotta go. Guys, this is ridiculous. So I've got to go, but thank you for joining me. Make sure to like, subscribe. Mel's saging us all. Thank you, Mel. We can always count on you. Tag someone, share this video. And I'll be on Instagram as well if any new updates come today over Ashley, Brianna, Eve. But with that, guys, I really got to run. Thank you for being here. It is absolutely frustrating. And let's see what comes from this. All right, guys, I'll see you in the next one.